In this episode, I want to take a look at how you actually remove a company director. Disputes can arise from time to time. Hey, it's Terry Gorry, and this is the Irish Law and Small Business Podcast. Question of the removal of a director in a company. This is something that arises from time to time, obviously. There can be disputes or falling outs or any number of reasons why members or other directors might want to remove a director. The first thing to be said about the removal of a director is that in a single member company, in other words, one member, one shareholder, one owner, a sole member may remove a director by written resolution without holding an EGM. And we'll have a look at the requirement to hold an EGM shortly under Section 146 of the Companies Act 2014. But a sole member, a single member company can remove a director by written resolution without holding an EGM. Some of the issues arising then in relation to the removal of a director, before we take a look at it, would be whether the employer or whether the director has a contract of employment, or even if he or she does not have a contract of employment, if he's an executive director, then he is or she is an employee, and therefore procedural fairness is required, and you must deal with it, or you must take into account the requirement for natural justice, fair procedures and so on in determination of the employment, essentially. Also, the removal of a director, one of the issues arising is that the removal does not affect the director's right to compensation. So the director may have a right to compensation under the employment law, for example, and as I say, an executive director is also an employee of the company. There's also the question that a director may also be a shareholder, and if the director is a shareholder, then the question of the oppression of a minority shareholder may give rise to legal proceedings or a claim for oppression of a minority shareholder. The company's constitution then may give rise or may provide for the removal of a director in writing. It's unlikely, but it may have that provision in it. If it does, or indeed it may well have other methods of removing directors in the company's constitution, but your bog standard company's constitution probably does not have these special powers, and you probably be left with the provision of Section 146 of the Companies Act 2014. Before we move on to that, and before we look at what's involved in Section 146 of the Companies Act, you should bear in mind that, as always, an amicable parting or resignation is probably the most cost-effective way to deal with the removal of a director. In all of these disputes which arise and in which the law can be involved, it is generally the case that legal proceedings, legal disputes can be time-consuming and can be costly. So doing a deal, making terms, resignation, amicable parting should not be ruled out. In fact, should be probably the number one option to look at in the first instance. If then you're stuck with Section 146 of the Companies Act 2014, unless the directors themselves propose the resolution, the members must give extended notice of at least 28 days notice to the company that an ordinary resolution is to be proposed at an EGM, an extraordinary general meeting, to remove a director. The company then sends notice to the said director. The board meeting will hold an EGM, extraordinary general meeting. 21 days notice then must be given to members. 21 days notice to the members can be included in the 28 days that we've looked at in the first instance, where notice to the company that an ordinary resolution is to be proposed to remove a director. So members must get 21 days notice. The director then may make representations to the company or to the members. The board may also make representations to the members on whether it agrees or disagrees with the proposal to remove the director in question. Remember, the proposal may well come from the members and the directors may not agree with it, or they may agree with it. The director then is entitled to speak at the EGM, the Extraordinary General Meeting. The vacancy can be filled at the EGM there and then, or it can be filled later on. And then if the ordinary resolution to remove the director is passed, Form B10 needs to be filed at the company's registration office website or portal, and the statutory record or the records of the company itself must be updated. So that is the position in relation to the removal of a director. It can be messy, it can be amicable. The best way, as I say, is resignation and some sort of an amicable parting of the ways, but if necessary, and if the company's constitution does not make provision for it specifically, then you can always rely on the Companies Act 2014, Section 146, and do bear in mind that the director, who is an executive director, is also an employee and is entitled to procedural fairness, and there may well be employment law considerations to be factored in, so you probably should get legal advice. You should definitely get legal advice, in fact. The question then, obviously, of a director being a shareholder is something that needs to be considered, because there is the question of some sort of a civil action for the oppression of that director's rights as a minority shareholder.
Thanks a lot for listening, and don't forget to subscribe so that you won't miss an episode.